Ndoromo trial that make him to be homeless and jobless and wandering in the street all the time. The trial ends on March 29, 2007. The prosecutor, judge, and the defense lawyers ends the trial without the second phase of the trial for the petitioner or Akube Ndoromo to present the second phase of the trial to prove his innocence in violation of his Fifth Amendment, Sixth Amendment, and the C Docket Entry number 15, 16, 17, entered date November 14, 2006. Docket Entry also number 48, 49, dated on as entry date on June 1, 2007. Docket Entry number 60, entered date September 14, 2007. Docket number 65, entered date November 7, 2007. And docket entry number 78, entry date February 2, 2008. On March 29, 2007, the defense counsel told Mr. Ndoromo that Mr. Ndoromo could not present the second phase of the trial because the case was a mistrial due to government failure to prove all elements beyond reasonable doubt. The defense counsel sent the entire Akube Ndoromo's witnesses home and sent Mr. Ndoromo home to come next day for the declaration of mistrial, but ended in one phase of trial and then never presented to jury for deliberation. And in 20 minutes, Mr. Ndoromo, the jury was sent inside. Mr. Ndoromo went outside. The results from jury came back, which of course the jury never come back with a verdict of guilt in all counts presented. But the jury really, I don't think the jury really bet on it, because when Mr. Ndoromo was outside, he went outside within the 10 minutes, and he saw the jury were taken to the lunch, and some are coming back, and he was called to come back inside the court, and he was just right there locked up. Due to the bribe from Prosecutor Mr. Austin to Judge Emmet G, Sullivan, and the defense lawyer Rita Pendry. If you see in Dyer versus United States, confining fundamental miscarriage of justice to extraordinary instance when constitutional violation probably, or like the one of Mr. Ndoromo, caused the conviction of Ndoromo as innocent of crime. So, and again, also if you see U.S. versus Koch, confining fundamental miscarriage of justice to colorable showing of factual innocence, like in Akube Ndoromo's case, the petitioner witnesses were sent back without testifying for those witnesses that complained that their subpoena signed, had their subpoena signed and sent to be paid by the court for their coming. The government knowingly and intentionally seized 8 bank accounts totaling 1.2 million in reference to Title 18 United States Code Section 2113A, using illegal warrants, because legally any accounts can be seized from the bank. They can pause it, but they cannot seize it. Also see U.S. versus William, and also see in violation of Banking Insurance Act 12 United States Code Section 1812 and Section 1813, in violation of healthcare fraud, Title 18 United States Code Section 1347 and 1335, 2A2 and 982A7, because the accounts was not supposed to be seized by warrant, but it can be frozen. Also, in violation of wire fraud, Title 18 U.S.C. United States Code Section 1343, in violation of mail fraud, Title 18 United States Code Section 1341, and in violation of money laundering, Title 18 United States Code Section 1956 and 1957. Seizing those accounts in the bank account alone is a violation. In violation of 4th, 5th, and 6th Amendment. See superseding indictment, docket entry number 3, entry day February 1st, 2006, page number 4, bank accounts, governments false mislead the grand jury that Akube Ndoromo still have those accounts. The arbitrary and the discriminatory government, it is only where enforcement agents exercise discrimination power arbitrarily and unjustly that enforcement of valid regulation becomes violated of the clause, like in situation of Akube Ndoromo. And see Thompson versus Spare. So, Saroy denied. And also, the Constitution rejects those violations in reference to 9th Amendment and the C Bill of Rights at Sikesh versus Wapaw County. So affirmed by the Supreme Court, affirms also. And Title 28, United States Section 2255 as well can be also used to challenge in consideration unconstitutionally in pre-trial, which already I delivered that. And if you see the trial judge in this case knows all the disputed evidence, facts, see United States of America versus 455,273.72 cents in funds from the Bank of America. This is civil number 1.05 and the CB 00356 under Judge Emmet G. Sullivan, the corrupted judge. And Ndoromo versus United States, this is civil number 1.06 CB 00150 under the same Judge Emmet G. Sullivan, the corrupted judge. The trial court ignores the violations of the United States Constitution by government because the Judge Emmet G. Sullivan was given something by Prosecutor Roy Austin. Thank you, and I will also, whatever I say, I will put some written document behind it to back it up, and also you can see it. And I'm seeking for help, for public support to rally so we can stop the DC government or judicial robbery and the corruption that is going on for years. Thank you, and they are seeking a public help. All right now.